is in, as we told you earlier, and now we know Ed Sheeran has been found not liable. John, this just in from that U.S. District Court room a few moments ago. Our producer in the room said Ed Sheeran stood up upon the reading of the verdict and hugged his team, knowing that he had said before this and before this court hearing this week that had he lost, he would be quitting music. John.
Hey, man, it's getting tight out here. For those of you who don't know, I am Dave, a 10-year intellectual property attorney dealing with everything from patents, trademarks, trade secrets, as well as copyrights. And Ed Sheeran, which, again, I know he's a humongous star. I think he's from across the pond. I know he did some music or whatever the case may be with Beyonce and some of the other artists I know and kind of have listened to their music. He was being sued by Marvin Gaye's estate. And it seems like for the Let's Get It On, man, I love that song, Let's Get It On. Let's get it on. I was listening to that song over the weekend. Love Motown music. And it seems like Ed Sheeran said if he did not win this case, he was quitting music. Now, you have to let me know in the comment section, do you think he would have quit music to the extent that he lost this case? Now, we know we don't have to worry about it because as the news anchor just pointed out, and we'll get back to the news story here in a second, the Supreme Court, we're talking about the highest court of the land, the Supreme Court of the United States, ruled in favor of Ed Sheeran. Really, actually, they didn't rule in favor. They just said they wasn't going to, I think, pick up the case, if I recall correctly. But in any event, he essentially was found not liable for copyright infringement and therefore don't have to pay a ton of money. And he's still making music for all his fans. So let's get back off into it and see what the news anchors say about what the Supreme Court said and Ed Sheeran said. And I'll continue to give you my thoughts as intellectual property attorney who's been doing this for over 10 years. Let's go. Hit that like button as well. Add the subscribe button for your boy. Let's go.
This is just into us now, the verdict.
Yeah, and you know, you talk about what part of the song is alike. The chord structure is identical. It goes D, then D with an F sharp bass to a G to an A, and then the next cycle around goes D, F sharp minor to a G to an A. The chord structure and the tempo, exactly the same. Though Marvin Gaye's was recorded a half a step higher than Ed Sheeran's was. But it's the melody that's completely different. And it's typically the melody that is what is at issue here when we're talking about copyright infringement.
He's been apparently so upset that his grandmother passed and he was not able to attend. His father told attendees he just was too upset to do so as this court case was ongoing. Lydia Hu is joining us now from the Fox Business Network. She's outside the New York City courthouse with the very latest from there. Lydia.
Hi there, Sandra and John. That's right. This verdict's coming in, finding Ed Sheeran not liable in this copyright action that was filed by Marvin Gaye's co-writer, his family members of his famous song, Let's Getting On. They were alleging that Ed Sheeran's Grammy Award-winning song, Thinking Out Loud, infringed on copyright protection here. Now that this case has come to a close with a finding in favor of Ed Sheeran being not liable on these copyright claims, this will conclude the 2-week matter. It took the members of the jury a matter of about 2.5 hours today in deliberations. They got the case around a little after 5 p.m. last night and adjourned for the evening, reconvening this morning to consider the charges that have been the claims that have been levied against him, deciding again that he is not liable. Just to back up and bring you a little bit more context around this case, this trial really captivated the attention of the music industry here because it's the latest example of a copyright case that was testing questions about common parts of music and whether composers, musicians, and songwriters can own parts of music.
And I do want to kind of bring it back on myself here really quickly. The different thing, and I always like this about patents and trademarks, is it goes through an examination process before it gets awarded. So before you get a trademark on something, before you get a patent on something, and it's dealing with the United States Patent and Trademark Office, examiners at the Patent and Trademark Office examines your trademark application, examines your patent application, and then at that point, to the extent that there's nothing out there and it's new, it's obvious, whatever the case may be, they will let you know that you are awarded a trademark or a patent on your particular IP. However, copyrights is different, which is kind of a good and a bad thing. Number one, you're dealing with the Copyright Office, but there's no examination process beforehand. You actually get a copyright to the extent that you write a book. You got a copyright on that book right then and there. you don't really have to even file for copyright protection. Now, you do have to file with the Copyright Office to the extent that you want to sue somebody for copyright infringement. You have to file that copyright with the Copyright Office before you sue. However, as soon as you fix your creative work in a what we call a tangible medium, then you have a copyright then and there. But the bad thing, so that's a good thing. You don't have to file for a copyright; you automatically get it. But then the bad thing is, and kind of what this case was, what the lady was talking about, the strength of your copyright actually gets examined as you are in court. So, for example, you file for, you get a copyright as soon as you kind of, create the music. Then when you want to sue somebody, then you have to file for, to the extent that you didn't file for that, file with the Copyright Office, your copyright, you file it and then you sue somebody. But then the court is going to actually look at the music and say whether or not you are, how strong is your copyright, which again, that's the part I don't like about it, because the strength of the copyright is examined on the back end, as opposed to with trademarks and patents is examined on the front end. It seems like in this case, at least what the lady was saying, that the court found that, hey, his music, number one, it had a copyright, but also it did not infringe on the copyright of Marvin Gaye. And I guess I didn't realize what Ed or whatever the case may be, he had a co-writer on the Let's Get It On music. It did not infringe on that copyright, because it was, it essentially was a common part of kind of what musicians, when they're making beats or whatever the case may be, making music, it's more of a common theme. It's almost like, say you take a picture of something and you have that sunset in the background. That sunset that's in the background, yeah, it's going to be part of the copyright, but it's going to be looked at as very limiting as it relates to the copyright portion of it, just because how many pictures do we know have a sun in the background, or a sunset, or whatever the case may be. That's a part of a lot of pictures and things like that. So with regard to the whole copyright image, that sunset in the background is going to get narrow protection. And that's what it seems like they're saying with the Ed Sheeran case, or the Let's Get It On. That part that was kind of similar, the protection was so narrow on it that Ed Sheeran did not copyright or commit copyright infringement on that portion of it, because of the narrowness of the strength of the copyright. So hopefully you guys got that. Let me know in the comment section if you did get it or understand it. But again, the fact that the copyrights are examined on the back end, and really with the copyrights, if you can show that you independently created something, then it's really no copyright infringement. Obviously, it's going to be tough for Ed Sheeran to say, hey, the Let's Get It On, which is kind of known worldwide, he did not hear it. So that probably wasn't going to be an argument in this case. But essentially what I would imagine that his counsel, his legal team argued is, hey, this is different. And to the extent that, Let's Get It On, he has a copyright on that portion, it should be very limited or narrow, because everybody is using, again, I'm not a big music guy, but those chords to kind of make music or whatever the case may be. So again, man, some interesting stuff. Thankfully, Ed Sheeran did not have to quit music. Let's kind of see what else Fox has to say about this one, and then we'll wrap it up. Let's go.
And the chords as they're assembled, or whether chords and parts of the music, as John was just speaking to, kind of become part of more of the public domain and be used and other works by other composers. In this case, used by Ed Sheeran. And in this trial, obviously the jury members finding in favor of Ed Sheeran here. Now, in the days leading up to this decision, in the days of this trial, Kathleen Townsend Griffin, who is the daughter of Ed Townsend, she is one of the plaintiffs. She is a descendant of the co-writer who wrote the song Let's Get It On with Marvin Gaye, told reporters outside of the courthouse that she was, quote, expecting that's her father, Mr. Ed Townsend, expecting his name and his work to be honored and all the art's intellectual property to be respected. That is a quote. Meanwhile, Sandra, as you mentioned a moment ago, the New York Post reported from inside the courtroom that Ed Sheeran, who took the stand to defend his own work, even playing his guitar at moments, told members of the jury that if this jury were to find against him, and if in fact they had found that he violated copyright laws, that he would, quote, if that happens, I'm done, I'm stopping. Well, it seems like that is not going to be the
Man, shout out to Ed Sheeran. He does not have to quit. That's crazy to tell the jury that. It seems like he was going through it to not go to your grandmother's funeral over kind of this copyright situation that you found yourself in. That seems a little extreme in my opinion. But again, I would imagine that it was a pretty stressful time for him. Thank God that he was found not liable, and therefore he can continue on to do his thing. Like I said before, man, the copyright stuff is interesting because the strength of the copyright really gets examined during a trial as opposed to kind of beforehand. And it seems like in this case, he was able to convince the jury that, hey, this was not copyright infringement in light of the famous Let's Get It On by that was sung by Marvin Gaye. It seems like Ed Townsend was a co-writer, co-producer on that. And it seems like his estate, that's another good thing about the copyrights, is the lead time is good for the life of the author plus 70 years. So we're talking about Ed Townsend, his kids or his grandkids, whatever the case may be, his estate was suing Ed Sheeran. Was it trying to get some money from it? Seems like those famous music, the Let's Get It On, the different music by Michael Jackson that his estates kind of put forth with the copyrights and protects, those typically are going to be protected vigorously because they are popular music. So I guess it's not surprising that the estate of Ed Townsend sued Ed Sheeran with the Let's Get It On. It seemed like in this case, unfortunately, they did not win because, again, seems like the narrowness of that part of the copyright, Ed Sheeran was able to kind of get around and say, hey, it wasn't copyright infringement. Again, shouts out to him. Let me know what you guys think in the comment section. This copyright stuff is interesting. We all know about the AI stuff that's out there and can affect this stuff, particularly as it relates to books and illustrations, whatever the case may be. We know AI is covered also with the music, so that'd be interesting. It seems like Ed Sheeran, he kind of lived to make music for another day. So shout out to him on being able to get over this. It'll be interesting on whether or not they are able to. They said the Supreme Court, but I'm not sure if it was the Supreme Court because it was in the U.S. New York City. I know the Supreme Court is actually, I think in D.C. if I'm not mistaken. So I'm not sure if this was the Supreme Court of New York. I know they call their lower court the Supreme Court, but again, this should be a federal matter. So I have to kind of take a deeper dive at this one. But shouts out to Ed Sheeran, and hopefully you guys enjoyed this one. Hit that like button for the YouTube algorithm, as well as hit that subscribe button to be a part of the IP community. And I'll catch you guys next time. Peace.